Welcome. I hope you all had a great Thanksgiving. As we always start, we're going to start with some research. Today is regarding qualified custodians. And the title here, you can't keep your own electronic will, and what that means. So the legal rule in Washington state, if you or a beneficiary hold custody of your electronic will, the law treats it as a lost will or a destroyed will for purposes of the probate. This is because only a qualified custodian can provide the required affidavit of integrity, which is essential to make your e-will self-proving. And it's not called an affidavit of integrity, but per se, but essentially you're going to do an affidavit that says that this is a authentic will as a qualified custodian. So without this, the will must go through a costly and risky, likely court battle to prove its authenticity, and we're going to get into that here. So you don't want to do self-custody. That equals essentially a legal failure. If you store your e-will in your personal Google Drive or any drive, or on your phone or on a thumb drive, you lose the legal standing that you want, which is the law assumes the document is no longer secure or verifiable. And then you have custody by a trusted third party, like a legal custodian. That equals legal protection. So a qualified custodian legally guarantees the will's integrity and provides a sworn affidavit for you that they can submit to the court, which is essentially proving that it's never been altered. So why does this rule exist? Well, there's a lot of danger around digital and electronic documents, essentially digital fraud. So physical wills use wet ink. Any tampering leaves visible evidence. So it's really difficult to tamper with physical documents. People do it, and it's a situation where a lot of times they get caught. You have to be really, really, really good because there's experts that can tell if things have been altered. But digital files really can be edited very easily and without a trace. A single person with access can alter the will, delete it, or replace it with a false version without really any expertise, because there's so many online tools that can edit PDFs like it's nothing. So this makes digital wills vulnerable to fraud unless protected by a strict legal framework. The qualified custodian rule was created specifically to prevent this. So if you have no physical evidence, this equals no proof of authenticity if it's all electronic. So a digital file stored on your device can be copied, renamed, modified. The metadata can be deleted. So you essentially have no physical footprint for the document, and you also have no digital footprint because it can be erased. So also there's legal proof. Trust is in the process for a qualified custodian. A qualified custodian maintains exclusive access and provides a sworn statement confirming the document's integrity over time. What a qualified custodian actually does with your last will and testament. Their core duties are that they maintain exclusive custody of the e-will at all times, no access to the beneficiary of the heirs. They're not allowed to see the will until you pass away. Provides a sworn statement under penalty of perjury to the probate court. They deliver the will to the court within 30 days of request or to the personal representative, and then ensure the document presented is exact, unaltered version signed by the testator. This legal structure protects your family from fraud and delays. All right, so furthermore, it prevents insider tampering. Exclusive custody prevents beneficiaries from accessing and altering the will because they don't have access to it. Only the qualified custodian does, who doesn't have a horse in the race, essentially. They just have the will, but they're not a beneficiary. So this stops the temptation to change it for personal gain, which, like we said, can be easily done. The sworn affidavit is legally binding and accepted by the courts as proof of authenticity. And this saves time and money for families and pretty much just makes it very straightforward. So it eliminates the need for expensive and emotional court battles where somebody says, I don't know if you altered it or not. Well, we know that they didn't alter it because it was with a qualified custodian. The catastrophic risk of self-custody. So what happens when you do self-custody and why it backfires? So you're giving your e-will to a spouse, child, or a friend named in the will creates a conflict of interest. Clearly, because they're very incentivized to do things because they're the ones who are going to be affected by the will. So that person had both access and motive to alter it potentially. And if they claim later the will was changed or forged, the court may reject it entirely. In the worst case, your estate is distributed incorrectly and your family is left in legal limbo, or it's distributed in a way that is more based on the intestate procedures, which means you have no will. So this is not just a risk, it's a legal certainty that you're going to have issues, or it's going to complicate your probate under Washington law. It's just how much is it going to complicate it is the question. So you can't keep your own electronic will, and that's a good thing. And that's the bottom line. Trust is built into the law. It's not built into certain individuals, which, as I know, you expect people that they're going to do the right thing, but the law doesn't look at it like that. The law doesn't know how trustworthy somebody is. So they just have these procedures in place to ensure that your will is authentic when it's admitted to probate. What's the final takeaway? Washington State's qualified custodian rule is not a limitation, it's a legal safeguard. It ensures that your electronic will is secure, viable, and legally valid by requiring a third-party custodian. The law protects your family from fraud, delays, and emotional turmoil that can happen when somebody just doesn't really buy that the will wasn't altered, because we don't know. How do you even know that it was signed at all based on a lot of these electronic wills, or if they actually signed it? And that's why it has to go through a whole electronic process with a electronic notary and a qualified custodian who is typically the same person. So the convenience of digital wills is only as strong as the legal foundation that supports them. Choose a qualified custodian to make your digital will truly work and truly be accepted by the court. Because, I think courts are going to be very, very hesitant, and just based on the law, but just based on practical, how courts typically work. This is a new thing, so you want to really do it the right way to make sure that it actually is accepted. All right, questions, make sure you can leave any comment that you'd like, and I'll try to respond to those. And as always, let's talk to an attorney before you do any decision making on qualified custodians or last will and testaments, especially electronic wills. Thank you.